Adler, and I am pleased to be the speaker for today's Ivy webinar. Just want to make sure everybody hears me okay out there and check in with everybody. Where are you folks all from? I saw some of the comments here before this webinar went live. I did see that we have an Australian joining us today, and I can tell you that there are a great deal of similarities between Australian contract law and U.S. contract law. In fact, there are several Australian cases I'm aware of where they've actually cited to U.S. law, and that's typically in sort of the newer area around the internet and some of that. But both systems are based on a common law approach, and contract law is pretty universal. Most of the rights and obligations and remedies have been pretty well settled over the last few hundred years. So there's going to be a lot of similarities, at least for the purposes of the webinar today. Glad to see so many people from all across the U.S. I represent clients from New York to San Francisco, and even outside the U.S. I have design clients in the U.K. And France. So everybody's welcome, and hopefully my experience spans a pretty broad range of geographies, and I do understand that clients and projects kind of vary from place to place. So I will do my best to kind of generalize, and I think everybody should get something here that is pretty useful. I want to take a moment to thank Ivy for hosting the webinar. It's this great setup. I appreciate the opportunity to speak to the Ivy network. I know you folks are all very collaborative and very supportive of one another, so it's a privilege and honor for me to be here, and want to thank Ivy for inviting me along. So I know we've got a couple minutes here. I think we'll start right at 12:30 Eastern Time, 11:30 here in Chicago. So I'm just giving everybody a few minutes to sort of wander in the door, so to speak, and then I'm pretty sure we'll be able to jump right in. I also noticed from some of the posts that some people have seen me speak elsewhere, and have missed some of my speaking engagements. So hopefully this will be a good introduction to the type of work I do and how I work with my designer clients. And then also know that there are future events coming up. I do travel a bit, and I do really enjoy teaching classes and providing information to my designer clients throughout the U.S., design communities everywhere. So I know it's something that designers don't always get access to, and certainly have a lot of questions about. So it's really, it's my pleasure to be able to share my knowledge and experience. And ultimately, my hope is to make you a better business person, a better designer, and really help you get all the value that you can out of your contracts. So again, we'll give it another minute or two here. Try and keep everybody entertained. Certainly use the chat feature if you have questions about the presentation. When I do the introduction, I'll kind of give you a better sense of what we're going to hit today, and we will certainly save time at the end to answer questions, as many as I can or as best I can. Obviously, there's some limitations on what we can do here, but more than happy to try and clarify any of the things that I talk about today, or answer any questions that are of a general enough nature that we can kind of apply them to everybody. Somebody thinks they saw me speak at Launch Seminar in Los Angeles. I wish that was me. I did not attend Launch in Los Angeles. However, I have spoken in New York and Atlanta. I've also taught similar classes in San Francisco, and certainly looking to do more of that. So for those of you who are maybe clustered in larger cities and have a local organization that is a good platform for this type of educational content, I'm more than happy to come out and be a speaker for you all. So I think that we are at the appointed time. And what I would like to do now is go ahead and jump into the presentation. So bear with me while I kind of switch over my computer here and we get this slideshow up for everybody. Okay, great. Well, again, here we are. This is the Ivy webinar about 5 things that every contract needs. So this is so kind of a superficial kind of a gloss on some of this stuff. I did want to get in some introductory comments before we dive into the nitty-gritty legal stuff. You know, first of all, contract law is a fairly extensive subject. I don't know how many people know this, but law school's 3 years for the most part, and your entire first year of law school is spent covering contracts, both semesters. So it's a very detailed area of the law, it's a very well-developed area of the law, and it can be a very complicated area of the law. So I just want everybody to understand that there's just no way we are really going to get into any serious substantive discussions about contract law in a 45-minute webinar. It just, you know, it wouldn't do the subject justice, and I certainly wouldn't want any of our viewers today to walk away thinking that, you know, I really didn't do what I said I was going to do. We're going to look at some key areas in contracts, and I'm going to do my best to sort of relate those to some experiences that I've had with my clients and really try and make it tangible for you. The other disclaimer that I need to make is that while I am a lawyer, I am not your lawyer. So everything that I talk about today is really just general educational materials. It's not intended to be legal advice. It shouldn't be acted on as though it's legal advice. These are, you know, the things I'll talk about are basically, you know, to make you a better business person so you can understand the issues and so that you can, you know, have a meaningful discussion with your lawyer, whomever that might be, when it comes time to look at how you might be able to make your contracts better. So without further ado, let's jump right into contracts. So I always like to start the discussion around contracts with a basic understanding of the purpose of a contract, right? Why do we have written contracts? Well, primarily we have written contracts to avoid ambiguity, to avoid misunderstandings. When you're using a written contract, the purpose of the contract is so that everybody is clear on their rights, on their obligations, on the expectations of the parties. And as you can see from this quote, the idea is that all of the risks of the business, all of the risks of this relationship have been discussed and have been put into the contract. Any sort of reasonably foreseeable outcome, whether things go right or whether things go wrong, should be in the contract. And so before I get into kind of my top 5 things, I just wanted to share 2 examples of major contract mistakes that are likely to give you pause and really cause you to consider whether your contracts cover everything you need. So my favorite question to ask when I'm teaching my contract class is, what is a contract, right? And I get all kinds of answers. Sometimes people say, well, it's, you know, it's a written piece of paper. Sometimes people are more specific, like, well, it's a lease or something like that. And the truth is that a contract is simply a promise or a set of promises that the law will enforce. And that leads to the age-old saying that contracts are performed either, or contracts are honored either in their performance or their breach. And what that means is either both parties performed and the contract fulfilled the needs, or one or more parties failed to perform and the law stepped in to create a remedy. So this is the purpose. This is what a contract is: legally enforceable promises. And you know, how detailed we get in those promises is certainly dependent on the relationship and the type of the project, right? So my favorite example to lead with is the $1 million contract mistake. And Believe me when I say it was pretty hard for my clients to swallow this one. In a nutshell, early 2000s, my client had a small business here in Illinois. They hired a web developer to create an e-commerce website. Well, back then, you really couldn't buy this stuff off the shelf. Anything that was this detailed was really a lot of custom programming. Hence, the project totaled about $1 million. Actually, it was a little over $1 million by the time it was all said and done. And throughout the relationship, my client, the owner, had been emailing with the developer and discussing what the client wanted and what the client would pay and what the scope was. And it was a very traditional business relationship. My client paid for the services and the developer provided the services. Well, at the end of the day, my client had this beautiful e-commerce website. Lo and behold, about 6 months later, my clients learned that their biggest competitor now has launched their own e-commerce website, and that this e-commerce website is built on the exact same software foundation as my client's website. Now, the long and the short of it is that my clients didn't contact me until after this was over. Had they contacted me before beginning this project, we wouldn't be having this discussion. The reason that the case resulted the way it did, and essentially that my client was unable to prevent the developer from selling this software to third parties, has to do with the fact that they never signed a written contract. And in this case, it is directly applicable to copyright law, because copyright law says that the author of a work is the owner of that work, is the copyright owner. And if the work is a specially commissioned work or a work made for hire, which was certainly the intent of my client and the web developer, such an agreement must be in writing. Doesn't mean that it has to be on physical paper. It can be electronic, but you have to have an agreement between the parties that says this is a work made for hire. This is a specially commissioned project. My clients didn't have that. And so this was the $1 million lesson they learned, is that not having the proper contract ultimately resulted in them not owning what they had just spent $1 million developing. So that's a pretty stark lesson in both copyright and contract law. The second example that I like to lead with is a client designer of mine out of New York who made the $50,000 mistake. And basically, this was a well-intentioned designer who started a very large, long-term, and expensive project with a longtime friend. The project, I think, started out well, and because my client was somewhat new to the design business, she wasn't terribly sophisticated in her contracts, and with the help of her husband, who's a seasoned business professional, put together a 2-page contract that laid out a couple of the key things. And basically, it said that the designer would do design and she'd be paid for the cost of the goods plus 20%. And her service fee was based on 20%. Well, wouldn't you know, the relationship moves forward a few years. Eventually, the relationship starts to sour. The customer, the client in this case, has spent literally hundreds of thousands of dollars on the designer's time and on various additions to the home. And the client starts to get tired of paying the bill. And by the time that I'm brought into this case, the designer is now out of pocket $50,000 of its own money for services and fees and furniture and other items that have been delivered to the client. And so, of course, the first thing that I say to my client is, okay, let me see the contract, because I am sure that you are correct that this client owes you the money. And unfortunately, the contract that I got was a 2-page contract written by 2 people who were not lawyers. And unfortunately, it was just very vague, and it didn't have a lot of the teeth that a lawyer needs to be able to enforce a contract. And not even so much a lawyer, that a designer needs to be able to enforce the terms of the contract. The language was vague. The language was not well written in the sense that specific tasks weren't well defined, specific deliverables weren't well defined, specific obligations weren't well defined. It was just kind of a handshake deal. And, when it went south, that's when all of the problems arose. So with those 2 examples in mind, what we're going to talk about today are 5 things that I think need to be in your contract so that we can avoid those types of situations. And so just jump right in. These, and again, I'm speaking in broad generalizations. These are not the only 5 things that need to be in your contract, but I think if you have these 5 concepts and they're well developed, they're well thought out, and they are clear in their application, this will avoid problems in the future. So my 5 key things are scope, payment, purchasing, termination rights, and proprietary rights. So if you can't tick the box and know that your contract contains each one of these terms in reasonable detail, you're selling yourself short. You might be putting yourself in a position that you can't enforce your contract as well as you thought. Or you might be putting yourself in a position where you are unable to, to get more work, or, you're possibly leaving work on the table or money on the table, excuse me. And lastly, it's possibly that you're just not getting the full value out of the contract. So with these 5 key areas in mind, what I'd like to do now is kind of go through each one and give you a sense of sort of what I expect to see in a contract when I'm either reviewing a contract for a client or commenting on a contract for someone else. So the first thing that I think is absolutely key to every design contract is a detailed description of the scope, right? So this is what's going to be done. Are we doing a powder room? Are we doing a master bedroom? Are we doing the entire first floor? Are we doing a custom home? And are we doing commercial space? I have worked with clients in all those scenarios. I've had clients who've done very simple single room projects in a house, clients who've done more substantial full residence design projects. I've had clients who have done commercial projects. One of my clients did a foreign nation embassy. Another one of my clients actually was engaged in a design and build of a mixed-use commercial residential facility in another country. So obviously these things run the scale, and the larger the scale, the more important you get into the nuts and bolts of the details. And one of the issues that crops up for me from time to time is the fact that there's just a disconnect between the client's expectations and the designer's expectations. And this is one of those areas where you can really avoid those kinds of problems. So the scope, and a lot of people approach these in different ways. Sometimes I see contracts that are more in the nature of a proposal. So it kind of reads like a letter. It doesn't necessarily have all the detailed numbering and paragraph separation that some contracts have. And that's okay. It's simply a less formal style. As long as the substance is there, it's okay. One of the things I see, however, is that where a less formal style is used, you also seem to have a little bit less detail and a little bit less structure. So on the one hand, you have ease of use and you have accessibility, and you sort of have a friendly type of relationship. But on the other hand, you have something that's potentially a little watered down, maybe not as strong or detailed as it needs to be. And I see these shortcomings in a couple different areas. First is defining the tasks. A lot of designers take it for granted that when they have to design a room, there are many tasks that are involved in that. There are too many for me to break down, but essentially in your mind, designers know that you have to do certain things. The client, on the other hand, may not know that. The client, is looking to the designer to say, okay, these are the things I'm going to do. This is the order in which I'm going to do them. These are the things that I'm responsible for. These are the things that you're responsible for. And, I'm drawing this out. Doesn't necessarily need to be lengthy and wordy in the contract, as long as it's clear. And as long as there's some sort of objective breakdown of what will be done, by whom, and when. A second area where I see some issues crop up is around deliverables. Sometimes clients aren't really sure of what they're getting. This might be something larger, such as a redesign or a built-in, like let's say a butler's pantry, or a redesign of a kitchen with new cabinets and countertops, or something more simple as just a couple pieces of furniture. So what are those deliverables? What are the specific things that the client's getting? If there is, if it is furniture and fixtures, what are the terms around things like door pulls and drawer pulls and door handles, right? So those sort of minuscule things can crop up and become problems later if it's not clear. Another area where I see problems arise is around due dates. And this is due to the fact that not everything always comes in on time. So I had a situation here in Chicago with the designer came to me because her client had ordered some custom built cabinets and they were delayed. And unfortunately, the client, the homeowner, had a deadline that this work needed to be completed by a certain time. Unfortunately, that need wasn't necessarily communicated back to the fabricator. And so what happened was sort of a domino effect. We had, just things started to be manufactured late, they were delivered late, they were installed late, it caused other delays. So due dates are important because you need to think about how the project is scheduled, how it's going to go into effect, and you need to build in, or at least think about, what's going to happen along the way if dates need to be moved, if things aren't going to come in on time. The flip side of this coin is what happens when you as a designer are doing everything that you need to do, but the other side is holding things up. So something to think about is building in a mechanism that gives the designer some flexibility around these due dates when these delays are outside of the designer's control. Another area that I see that causes problems that really shouldn't cause problems are budgets. I'm actually kind of surprised at the number of designers I talk to who say they don't like to use budgets or they don't work up a budget with their client. And this could be for any number of reasons. But I found that if you have a budget and if you can list prices or at least price ranges for various aspects of the project, it will help keep the client, it will help keep the client on the same page. And it will certainly avoid those kind of, not ambiguous isn't the right word, but those situations where a client feels that maybe they're being taken advantage of, right? Maybe there has been something that has been spec'd for this project that the price just doesn't seem right, or the client potentially feels that they're overpaying for. If you can have a budget and if you can give yourself a guideline of what things will be purchased and what those costs will look like, it really helps keep the client on the same page. Lastly, we all know that things change. Life happens. Things get in the way. There are delays. There are unforeseen circumstances. I'm frequently surprised at how often design contracts don't have a mechanism to accommodate modifications and approvals. And this basically means that both sides should be able to discuss when a modification needs to be made and how that approval process is going to work. Neither side should have sort of the unilateral right to say, you have to do X. I have seen designers say, this project is taking too long, I'm raising my fee by X% or X number of dollars, or this started out as a bathroom renovation and now it's become a full floor renovation. And had I known, I would have bid my time differently, or I would have structured this project differently. Now that we're in it and I'm, waist deep in this, I don't feel that I'm getting paid and it's taking more time. I frequently get concerns from designers who feel that they've been put in a position that the client is taking more time than the designer originally thought. The client is expanding the scope beyond what was originally discussed. And so that's why it's important to have this mechanism here to make modifications to that scope and to provide a checks and balances approach in terms of approval, so that certain types of modifications might be foreseen and others might require a conversation. It seems to me that oftentimes my designer clients, in an effort to maintain the business relationship, really put themselves out and really kind of put themselves from a business standpoint in a position where they're either not being compensated fairly or they're putting in time that they shouldn't have to put in. Some examples that come to mind are 3, 4, 5 trips to the design center to look at drawer pulls. And literally I've had designer clients come to me and say, I had this client out to the same, let's call it the Merchandise Mart here in Chicago, to the same vendor 12 times, right? And in that case, that designer's contract didn't say that they were being compensated by the hour or how that time should be compensated. The designer saw their job as helping the client select drawer pulls. The designer figured, okay, I'll make some suggestions. The client will make some comments and we'll choose a final selection. And in fact, this client was simply unable to make up her mind. And because she wasn't paying for it, she kept wanting to go back. So again, this is one of those situations where some just forethought in the drafting might be able to save you some headache later. The second area in my top 5 is the payment section. And this is another one of these sections that I feel is both misunderstood and often overlooked. And as between the client and the designer, this is probably the second most frequent area where disagreements or conflicts arise. So my recommendation and my goal with my design clients is always to make sure that there are clear rules in the contract for how the designer is being paid, what costs can be recovered, and how the fee and payment structure is going to work. So service fees, I've seen every type of combination. I've had designers who've had an hourly on top of a per diem, on top of a service fee, on top of a management fee, on top of a design fee, as well as a markup for purchased items, okay? Some of my clients are on the opposite end of that spectrum and simply choose to do a flat fee. Maybe it's just a simple design and it's capable of being done as a flat fee. Some of my clients are strictly hourly and they like to just bill for the time that they spend providing the services. And some clients simply take a percentage fee of whatever the cost was. So if it's, if you're buying furniture and you're buying fixtures and you are maybe hiring contractors to do some of the work, the fee would be based on a percentage of that. Now, each one of these methods has its own pros and cons, okay? I cannot really get into the nitty-gritty of a lot of this stuff. I've had designers disagree with me over different formulas to use and why they might use one versus the other. For me, I'm agnostic. I really don't care how you get paid as long as you get paid, right? My concern is that the mechanisms in the contract are clear for the services that you're going to provide and how you're going to be compensated for those services. If you go back to my client, the example there with the $50,000 contract mistake, one of the problems in that contract was that it sort of opened up the door to the client being able to say, well, I'm not sure I'm paying you the right amount. If you recall in that example, my client is being paid based on a percentage fee. Well, that sort of invites the question by the client, what is the base cost of the amount, or the base cost on which I'm paying that percentage fee? I have a right to know. So again, my goal as a lawyer is to make sure that these payment terms and fee terms don't lend themselves to questioning or potentially conflicting interpretations. My goal is to make it very, very clear about what the designer is paid for and when. Second area under payment that I see a lot of variations on are expenses. I feel that designers should be entitled to reimbursement for their expenses. But that's something that really needs to be discussed with the client, so the client has an understanding of what type of expenses might be incurred when the designer is performing design services. And as kind of an aside, if you're looking at a contract from the perspective of how can I legally enforce these terms, expenses are the types of costs which may or may not be reimbursed by a court if this was a litigation situation and a designer was trying to enforce the terms of the contract. Typical expenses are everything from travel costs, lodging, meals, things of that nature. Now, when I'm on the side of the client and somebody shows me an expense clause and say, I'm going to be reimbursed for all expenses, I kind of put on a different hat and I say, okay, well, let's limit this. How can we scale this back so that I, as a customer, at least have some visibility into what those expenses might be, as well as maybe some controls? So one mechanism that I've seen used effectively is sort of a cap or a floor on expenses, either no expenses over a certain amount without consent, or if it's going to be for travel fees or meal fees, anything under a certain dollar amount would be considered okay. So there's different ways to work with expenses to kind of give it some flexibility to accommodate for the fact that these things aren't necessarily set in stone, but also give it enough detail so that both the designer and the client are on the same page as to what these kind of costs and fees are going to look like. The third area, invoicing, payment due dates, and late fees, is also an important area to consider. A lot of contracts do not have language that allows them to charge late fees. And while most clients do pay on time, it's helpful as a designer to kind of have that extra incentive to say, hey, you know what, the invoice is late. It's now subject to a late fee. The longer it takes you to pay, the more you're going to have to pay. On the flip side, again, going to the litigation mode, if you're telling a court that you're out of pocket because the client didn't pay, if your contract says that you're also entitled to late fees, well, that is additional damages that can be added to the amount that's owed. Lastly, I always make sure that clients understand the need to add terms around collection costs and attorney's fees. A court will not award costs and attorney's fees. It's the American rule. Basically is everybody pays their own way. And specifically in contract cases, contract damages can only come from the contract. Things like collection costs and attorney's fees, although related to that relationship, are not necessarily directly a result from the contract. So if you are a plaintiff or even a defendant, but if you're involved in a lawsuit, it's important to know whether the contract allows for fee shifting. Now, there are some statutory causes of action that do allow fee shifting. So, for example, most states will have a contracts fraud type statute, and oftentimes a fraud cause of action will have fee shifting in it. And sometimes, or fairly regularly, you will see a fraud claim bundled with a contract claim, but that's not always the case. But at least with respect to the contract, if you want to be able to recover costs and attorney's fees, it has to be in the contract. Another sort of maybe ancillary benefit of that is if there is starting to become some tension between the designer and the client, or if the relationship is breaking down, or if the client is refusing to pay, the designer can then go to the contract and say, hey, listen, you got to pay this, because if you don't, and I have to go to court, you've got to pay for that too, right? So it's kind of it's a bit of a stick in terms of the carrot and stick metaphor, but it's certainly something that should be in every contract. The third area where I see a lot of conflict is around purchasing. And due to the time constraints of the webinar today, there's really not a whole lot that I can do to delve into this. Many designers have different approaches to this. It is a somewhat sensitive topic. It's one of those topics that definitely creates friction. And designers have different viewpoints on how this area should be handled. My goal is really for you to understand that you have to be clear about it, unambiguous about it. The client needs to understand how the purchasing is going to work, and how payment is going to work, and how compensation is going to work, right? And I'm not telling you there's a right way or a wrong way to do it, as long as everybody understands exactly what's being done. As you'll see, this is for new clients, for people who are coming to interior design and hiring a designer for the first time. This is something they probably just don't understand. They haven't had exposure to it. They don't know how it works, and they're probably going to feel a little intimidated by it. So as a designer, it's helpful for you to explain to them, listen, this is how purchasing works. This is how, this is where I shop for products that I am going to show to you. You may or may not want to describe how the trade discount works. You may or may not want to extend discounts to customers, okay? But I think it's important to explain to them how it is to work with the showrooms, why it is that many showrooms are not open to the public. They're only open to the trade. I've seen situations where a client has been taken to a showroom only to go back to that showroom without the designer and say, oh, designer so-and-so said I could go ahead and purchase this item and you would give me their trade discount, okay? So these type of issues arise. Second area under purchasing is the requirements around buying custom products. Most of the designers I come into contact with understand the risk here, right? Nobody wants to order and pay for a custom item that the client is ultimately not going to keep or going to refuse. So, anytime you're dealing with custom work, you definitely need to make sure that you're getting some kind of deposit, or that the contract is clear about how the purchasing and the billing is going to work around that. Sometimes the design contracts I've seen are silent around freight, warehousing, delivery, installation, and insurance. I've had situations where one of my designer clients in California literally had some guy's house worth of furniture sitting in her garage for a year, and she didn't know what to do with it. She could have charged him rent. She could have done something else with it. But basically what it did is it caused a huge inconvenience for her for a year, and it was a lost business opportunity and blah, 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 right? But that was because the contract wasn't clear about how those issues were going to be handled. Talked a little bit about custom products. Again, it's key to discussing the payment and the ordering process. It's important for clients to understand. Oftentimes, there's no refund, there's no return, there's no exchange. Some manufacturers are better than others. So you might have a relationship with a manufacturer who can make something work. But the exception is really the rule here. And that's, most of the time this stuff can't be returned, can't be resold. Lastly is the idea around alternative sourcing. I know this is sort of a hot spot for designers when they come into a client's home and they say, look, these are the items that I've chosen for this particular design. And then the designer leaves, the client gets on the computer and starts looking at, some of the big name retailers. I don't want to name names, but you know who they are, and says, oh, okay, this may not be the exact same lamp that the designer chose, but here's one that looks close enough for me and it's half the price, so I'm just going to go ahead and order that one, right? So that's an issue that should be covered under purchasing. The fourth area of concern are around termination rights. And sometimes it's hard for designers to understand that they need to be thinking about how they're going to get out of the relationship, or how the relationship is going to end before they've even entered into the relationship. And so it can kind of be something that's not easy to think of, or something that just doesn't get thought of at the beginning. And basically, when you're thinking about termination rights, you're thinking about your ability to walk away from this relationship if you need to. And there's any number of reasons why you may want to walk away from this relationship. Maybe it's financially just not working out for you. Maybe the client is difficult to work with, or maybe the client is now disinterested, or maybe the client's circumstances have changed and the client just financially can't, complete this project the way they originally thought. So there are many, many different reasons why you might need to walk away from a contract. So what I have here are a couple different terms to think about to give yourself a mechanism to end that contract. And I know terminate's kind of a strong word. It often conjures up images of the Terminator from the movie franchise, right? But termination really just means to conclude the contract, to end it. So one of the best ways is to have some sort of language around termination for cause. And in this case, cause becomes a defined term. Cause can be anything from a failure to pay, a failure to perform, a failure to communicate, a change in circumstances. So you, as the designer and the client, can say, all right, these are the types of things that we think might be a reason to terminate the relationship. Now, that being said, just because a cause issue arose doesn't necessarily mean that you have to terminate the contract. There's also what's known as notice and cure. So notice and cure is a contractual provision that allows somebody who is in breach to make an effort to repair that breach, to fix things, to get back on the right side again. And usually these are, provisions that say, I'm going to give you notice that what you're doing is a breach of the contract. You're going to get a certain amount of time to correct that. And if at the end of that time period it remains uncorrected, then the contract's going to terminate, right? So the intent here is that it's fair to both sides. Neither party is stuck in a relationship or stuck in an agreement that they can't get out of, but it's still reasonable and it affords each side an opportunity to kind of make it right. So if somebody is not living up to their obligations under the contract, the notice and cure provision will give one side the right to say, hey, you're not living up to your obligations. I want you to fix that. And then, of course, it gives the other party the opportunity to fix it without throwing the whole relationship out the window. So that's the importance of termination for cause and notice and cure. In the absence of termination for cause, there's termination at will. And unless a contract says that is for a set period of time, for example, this contract shall continue in effect for 1 year, then the contract is terminable at will at either side. And that simply means that you can walk away at any time. Now, as the designer, you may not want the client to walk away at any time. Again, thinking back to those types of issues that cause friction between the designer and the client, maybe the client doesn't understand what you're doing, and maybe the client is hesitant to pay you, or maybe the client is, feeling that they're being taken advantage of. So, they say to you, hey, you know what, I'm just not happy with what you're doing. I'm done with this. I'm terminating the contract. Well, as a designer, you would probably want the opportunity to be told what the shortcomings are. What is it that you thought you did that you didn't do? Or What was it that you did that the client wasn't happy with, right? You should be given an opportunity to correct that. So again, it's very good for both sides to have that. The third area is the right to suspend performance. So maybe a situation has arisen that is not as severe as a breach. So we're not looking at terminating the contract, but maybe the designer needs to step back and say, okay, you know what, you haven't paid my last 2 invoices. I'm not going to do any more work until I get paid. Doesn't mean we're terminating the contract, but as soon as you pay me, we'll pick up right where we left off. Or it could be something like a communications breakdown. Maybe you're in that stage of the project where you're making different selections, and now the client has sort of become non-communicative or isn't really responding in a timely manner. And maybe some of this stuff needs to be done on a set schedule, or it needs to be done within a certain time period. And for whatever reason, the client is preventing you from getting it done. And then you can say, you know what, I'm going to step away from this. I'm not going to do any more work until X, Y, and Z occur, right? So that's the right to suspend performance. And then lastly, there's always the idea that, a designer might need, or in fact, the client might need the right to just kind of drop the project and cut their losses. Maybe, this is one of those situations where a designer is pouring their heart and energy and time into a project and it's just not going the right way, and the client's not going to be happy no matter what you do. And, sometimes you need to step back and say, this is just, this project just isn't working out. Before I spend more time and more energy and more resources trying to fix something that can't be fixed, maybe I just need to walk away. So all of these things are considerations for termination rights. And lastly, and I know we're kind of hitting that the time there that I wanted to save for questions. We're kind of wrapping up now, so I'm going to kind of gloss over proprietary rights. For those of you who know me, you know that this is one of my soapbox issues. I'm an intellectual property lawyer. I've been doing copyright, trademark, patent work for 20 years. I'm frequently on the side of the little guy and facing the Goliath on the other side. Most of my clients are small entrepreneurs or small creative professionals, small business owners, or people who are just starting out. And it always pains me to see that people have been taken advantage of because they just don't understand their rights when it comes to intellectual property. And I read somewhere that a well-known business coach in this field tries to teach her clients that you need to sell your services, not your rights. And so what does that mean in the interior design contract or context? Well, first of all, as a designer, everything you do is creative. Some or all of everything you touch really has an aspect of intellectual property to it. And for some of those things, there are intellectual property rights. And many times people forget about these things because they're not tangible and they don't understand how they arise or how they can be enforced. So in thinking about your design services and in looking at your contracts, how are you being protected for those things that you create and present to your clients? Do you have language in there that protects your sketches, that protects your photographs, that protects your designs? If you think about my first example of the $1 million contract mistake, this is exactly that problem. My clients did not have it written in their contract that they owned certain creative works, namely the software that they were paying to have developed, right? In this case, because you as a designer are providing services to the client and the client is paying for your services, the client likely thinks that they own all of the results and the proceeds of those services, any work product, any deliverables, right? But the law does not necessarily say that. You as the author, you as the designer own those creative works. So I always advise clients to make sure that they're protecting their rights and that the client is allowed to make full use of the design, to basically complete their project. But the client should not be allowed to take those designs and create new designs or take a design plan and apply it somewhere else. And I had a situation come up a couple weeks ago where somebody had been hired for a commercial project to design a certain area of a property, and the project grew, and the customer in that case actually took that design and then extrapolated it over other properties. And that was certainly not the designer's understanding, right? And not getting into the contract aspects of it, but that's one of those situations that can arise. Another issue that is very important for designers: make sure that you ask for display and attribution rights. Now, again, if you take the photograph, if you draw the design, if you set the stage, right? Those are things that you've done, and you should be able to photograph those, use those, social media, blogging, newsletters, website, what have you, okay? But it never hurts to have a little sentence in the contract to say that you're going to use those photos, and these clauses can be massaged. Obviously, if you have somebody who is, a notable client or a celebrity or somebody who's well known in the media, or you're working on a property that has those kinds of attributes, you may need to be a little bit more sensitive to that. But ultimately, what you want to do is kind of lay the groundwork to give yourself some flexibility. Another area where you can protect your proprietary rights is just keeping track of your sketches and drafts, making sure that you don't leave things behind with clients, things of that nature. And then lastly, an area that's kind of been growing a lot is confidential and proprietary information. So something to think about. The law is not going to create rights and obligations around confidential and proprietary information. Those rights and obligations will only come from the contract. So if this is something that's important to you as a designer, or if it's something that might be important to the client, there are things that should be thought about and should be addressed in the contract itself. So I know I've probably given you guys a lot to think about. I know I've really glossed over a lot of these key issues. My goal today was really just to get you to understand that, so these are the key issues in your contracts, and if you don't do anything else, that at least you kind of look at these areas and you say, okay, is this as clear and strong as it could be? Is there something that I could do to make this better for me or better for the client? Make it clearer in the event a misunderstanding arises. As a general rule, I always recommend that my clients periodically review their contracts. Maybe that means that once a year you pull the form out of the drawer and you say, hey, did all of these things work for me last year? Did I have a client situation come up that I couldn't find the right section in my contract to solve? Or have there been new developments in the law? It's, for example, there is now what's known as the Federal Defend Trade Secrets Act. It probably doesn't have a huge impact on interior designers, but the law has only been around for about a year, and it's caused a substantial rewrite in many services contracts where there's technical information or intellectual property involved. So, it's just one of these things. It's a law that came up that's causing people to go back and change their contracts. Sometimes there are state-based laws that are in your particular state that you might want to have addressed in a contract, and it may not exist in another state. So there's those situations. And then lastly, remember that these contracts are sort of a living piece of your business, and just like every client engagement is different, maybe there's not one size fits all contract for all situations. Not to say that you can't have a basic form contract, because I think everybody should, and that basic form should cover 95 to 97% of the relationship, but you definitely have those situations out there that are going to call for some customization. So again, I hope everybody found that useful. Believe me when I say that I understand that we just scratched the surface, and we could really do a much more lengthy discussion about any one of those 5 points. But hopefully, this is kind of giving you some vocabulary, it's giving you some food for thought, and will, kind of help you make better use of the contracts you have. So I guess what I'm going to do now, if I understand this correctly, is we're going to kind of shift back to the presentation part of this, and I am happy to entertain some questions from the designers in the audience. Okay, so I have this tab here. I've got some questions here that have been asked of me. The first one here is from Chandler, and the question is, how can you prevent clients from purchasing behind your back? Well, let me tell you, that is a question that all of my design clients have, and you know, the short answer is it depends. I have developed contract language for my contracts that I use that sort of define that purchasing relationship, and again, kind of create a carrot and stick approach to structuring that relationship, at least to create disincentives from the client going behind your back. Can you prevent it 100% of the time? You know, probably not. Are you going to sue every client that goes and does it in violation of the contract? Again, probably not. But, you know, it's been my experience that if you can put some pretty strong and constructive language in a contract, it gives you that leverage to, you know, keep your clients in line. So I know that's sort of a simplistic answer, but that's generally how I handle that question. There's another question here. Do you have language that you suggest to use regarding modifications and approvals? This is one of those areas that there's a pretty fair amount of standard boilerplate language out there, and really the idea is that there should be a mechanism for both parties to acknowledge that a modification needs to be made, and then a mechanism for either acceptance or rejection of that modification. So, for example, the parties may want to expand the scope of the project. Again, let's say we start with a bathroom and now we're doing a first floor. Well, the designer might say, okay, I'm happy to expand that scope, but my fees are going to increase by X, right? So then at that point, the ball kind of goes back to the client to say, okay, I can accept that, let's go ahead, or I can't accept that, can we meet somewhere in the middle? So basically, a structure that allows the parties to discuss the modification, discuss how that's going to affect either costs or timetables or deliverables, and then also a mechanism to allow the parties to proceed and not kind of get stuck in, a quagmire of neither side knowing who's what to do next. Sometimes if you have a situation where you frequently have modifications, you might have built-in language that says, unless it's rejected within 7 days, it's deemed accepted. Okay, so you can kind of put those types of triggers in as well. So the next question is there a template or place where designers can look for contracts specific to design? I know that there is, I think there's an ASID form contract out there, which is like 20 to 30 pages. It's really probably the most complete form in the industry. Unfortunately, from my perspective and the perspective of many of my designer clients, it's probably too complete. It's a little bit on the overkill side. I would tell you this, generally speaking, I'm hired by my clients to either update and tweak their existing contracts, or in some cases, I'm hired to create something from whole cloth. So yes, there are design contract templates out there. I would say be very, very wary of what you find and what you use. I can tell you that no lawyer puts his best work up on the internet for free. And even if you did come across a contract that really looked perfect, just had everything and all the details, you have to know that that contract was written for somebody else and it was specific to those parties and their situation. And it may not readily translate to what you want to do. So, just something to keep in mind. It's certainly worthwhile to go out there, look at the websites, look at the communities, Ask around, find out what people are using and what works for them. But at the end of the day, I always recommend having something tailored to your specific needs. So the next question here, should there be anything in the scope that addresses mistakes? So I guess this is one of those things. I don't know that you necessarily have to address mistakes specifically in the scope, but this could be one of those sections in the contracts that talks about what happens if something doesn't go as planned, right? Let's say you've ordered a custom sofa and it's supposed to be in burnt orange, and in fact it is a lime green, and now you're stuck with a product that's entirely not what you ordered, right? Is that your fault, the designer? No. Hopefully the client will understand that this is a mistake has been made, and you go back to the manufacturer and you say, listen, you sent me the wrong thing. Most of the time, those situations will kind of work themselves out. The bigger problem is when you have something that one side considers a mistake and the other side doesn't consider a mistake, and then you no longer have meeting of the minds. So here, the next question is, okay, so I've been asked here, can I address when clients, there are quite a few contracts here. Let's do, there's a question here about an architect taking credit for work, entering into contests, winning, accepting awards, and entering for publication. Well, this goes back to that whole discussion around proprietary rights, because what do you mean when you say an architect is taking credit for your work? It's intellectual property law protects certain things within certain boundaries, and I guess it would really sort of depend on the circumstances whether somebody is passing off something. So there are state and federal laws that prohibit somebody from passing off somebody else's work as their own in a way that deceives customers, right? And there's also, copyright law prevents somebody from copying your protected creative authorship and using it without your permission. And sort of the key to that is understanding what is protected creative authorship. And unfortunately, it's kind of outside the scope of this discussion today, but that question that you've asked is certainly a very important question, but it has a very nuanced and very complicated answer. And oftentimes it's really facts and circumstances dependent. I can tell you, if you are in a collaborative environment where you are working with other professionals, it is absolutely something to keep, at the top of your mind, and something that should be addressed in your contracts with your vendors and others, so that it's very, very clear as to who owns what. And this can be as specific as, the customer relationship, apart from things like the creative works themselves. So the next question here, how would you incorporate a line in the contract for the client going online and trying to duplicate the design? Again, this is sort of one of those proprietary rights questions. It really goes back to making sure you've defined what it is that you own and the limitations on what the client can do. Again, we live in a world where we don't know what our clients are going to do. We certainly can't look over their shoulder 24/7. We can't stop them from getting second opinions or looking things on their own. So, you have to kind of make sure that your contract has what it needs to have in order to protect you and protect the relationship. Some of the other questions, I think some of the stuff have been, I did see a question earlier about getting clients to sign, and I want to make sure that I addressed that, because I know that there's some confusion out there about whether what constitutes a written contract, whether you have to have an actual pen and ink signature on a piece of paper to get a contract. And the fact of the matter is that oral contracts meaning non-written contracts are just as effective as written contracts. The purpose of a signature is to manifest assent to agreement or assent to be bound by the contract. So what this means is as long as there's some indication that the other party is aware of what they're being asked to agree to and they have sort of manifest consent. A big X where it says signature could be evidence of, you know, assent to be bound by the terms of the contract. It doesn't need necessarily be a nice signature in cursive. I think the follow-up question here is whether you need to have a client sign each page, and oftentimes I think that comes from like the wills and trusts and real estate side of the law, because oftentimes you have these very lengthy documents, and sometimes changing a few words here or there can have a very, very material impact on how something's interpreted. So at least with wills and trusts, they have witnesses and the parties initial every page so that you can make sure that the entire thing is the whole. In the contract, or in contract law, the court can look to what's known as the four corners of the contract. So if it's a multiple page contract and you might be working with two different versions, the court can look at that. I don't think that you need to go through and have the client initial every single page. Not to say you can't do it. I know some people feel that that's, you know, very necessary and they want to be meticulous and it gives them a sense of comfort doing that, and that's perfectly okay. However, I don't think it's legally required. And if it's something that you'd rather not do, I think you're okay, you know, going without that. So I think that's all the time we have for today. It's certainly all the time that I have for today. Again, I really want to thank everybody who showed up. I hope you found it valuable. I hope you found it useful. I want to thank Ivy specifically for you know, promoting this, arranging this, making it possible for me to meet with you here today. And again, you know, certainly I'm available. You can reach out to me anytime if you've got questions. Like I said, I have clients around the world, so your specific location may not be a barrier to, in all likelihood, is not a barrier to working together. And I certainly wish you all the best of luck. And so this is David Adler signing off for Ivy today, and hope you all have a great rest of your day.